Well, hello everyone. How's everybody doing today? Yeah, you listen to Blind Intelligence. I'm your host, Foresight. Let me put out the disclaimer first before I go into anything what I want to go into today. All right? This is not legal advice. It's not financial advice. If you would like legal advice, if you would like financial advice, then I suggest you find yourself a competent professional and please be advised. What I'm about to say here is strictly for education and informational purposes only. And the views and opinions does not reflect any of the views and opinions of any platform that hosts Blind Intelligence. That includes YouTube. Now, how to legally get the debt collectors to back off is the question. How to legally get the debt collectors to back off. First of all, let me run real quick and give me a drink of water. Can y'all just bear with me for 1 second? I'm back with my water. Forgive me, I just finished eating an apple. Alright. Now we're back to what I was saying about how do we legally get the debt collectors to back off? Well, under 15 USC 1692G validation, that is a law, that is the consumer law, that you address the debt collector when they send you a letter. Whether if it's a debt junk buyer or a debt collector. Okay? If they send you a letter in the mail, you be proactive and you address that letter. And you keep 15 USC 1692G in your head. Because they have to validate the debt. And until they do, they must cease all communication. Because it's in that law. Go read it. You need to read that law. That's a very, very that law protects you. It protects you as a consumer. Under no circumstances you are to talk to them until they validate that debt. Cease and desist. I'm telling you this because this has happened to me. This has happened to my loved ones. They sent them a letter. They didn't know how to deal with it. They didn't know how to address that debt collector. So they gave me the letter, asking me to figure out how to asking me how do they address it. I said, don't worry about it. I wrote the letter because the letter was sent from Pennsylvania, right? And they live here in Mississippi. Never been to Pennsylvania. And so I just gave them a whole bunch of admonitions. I said the statutory limitations collected on a debt is 3 years in the state of Mississippi. I said you are in violation. I said that you need to cease and desist until you validate the debt. I sent them all types of, I didn't know what I was doing at the time, but I sent it and it went away. It went away. And this is what I'm saying. I didn't show no fear though. But it was clear. It wasn't sporadic. It wasn't all over the place. But I'm telling you, this is what you're going to have to do. All I had to do is tell them cease and desist. Cease and desist. Statutory limitation collecting on the debt is 3 years. I didn't have to go into anything else. You know, the first thing that we do when the debt collector calls us and we know that we don't owe that debt collector, we want to argue. We want to argue. Want to be argued. You got to remember one thing, that call is being recorded, and everything that you say can and will be used against you in the court of law. Right? So if they decide to take you to court, they got you on tape. They got you on transcript. And it is admissible in court. So I'm telling you, don't argue. Don't argue. Don't admit. Don't admit. Don't do none of that. Don't do none of that. Validation. 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 That's all you need to say. And until you do, cease and desist, hang up the phone. You write them a letter, get a copy. So I'm going to tell you, write them a letter. Make a copy of your letter, send a certified mail, get a return receipt. Tell them cease and desist under 15 U.S.C. 1692G. They must cease and desist all communications until they validate the debt. Period. Point blank. Send a certified mail, get a return receipt. When you get a 3011 card in the mail, that means they got it. They signed for it. Period. Point blank. Case over with that in that respect. Right? Okay. Now, this is how you get them to back off now. This video ain't full of fluff. This is how you get them to back off. Well, if it's a debt junk buyer or if it's a debt collector. But see, a debt collector is going to have they're going to validate the debt. Some of them. The ones that's on the up and up. A lot of the debt collectors that's on the up and up, they're going to validate the debt. Because they're going to have a consignment letter between them and the creditors, so they're saying that they can take over the debt, and it's going to be legit, right? Then you talk to them. But with a debt junk buyer, that's a whole other story, whole other broad game. They ain't going to have anything. So they're not going to have anything. The only thing they're going to have is a bunch of print. They're going to send you a bunch of printouts. No. I want a letter between you and me. A contract. A contract between you and me or between the creditor and yourself. Saying that you own this debt now. They ain't going to do it. They ain't going to do it. I ain't never seen them do it. I ain't never seen it. It's like I had that attorney from Michigan came at me. They came at me, one of Michigan, this attorney came at me from Michigan, and man, I'm like, okay, what's next, man? This crap, what's going on? I just filed bankruptcy. And I'm like, man, why is they sending me these letters? I know I ain't owe nothing. I just filed bankruptcy. That's how I remember. So I sent them a letter back, told them cease and desist. You can't get until you validate the debt under 15 U.S.C. 1692G. I said it at that time. I was dead up. I was dead serious about it. I'm like, nah, y'all not finna, you're not finna get me on that. Don't play. I don't owe y'all nothing. Don't even come at me with that. Don't even come in with no letters. You know? So they cease and desist. It will go away. I'm telling you. But look, I understand. Look, I know. I'm gonna just tell you. They have I don't have no proof, but I do. I do have a proof because it's in my computer. It's in my computer in my back office. But Yeah, I save my letters. I do save my letters. But what I'm saying to you is that this is how you get them to back off. This is how you get them to back off. Okay, all right. Now, I'm going to go deeper, right? Okay. Let's say, for example, that it's a debt collector, and that debt collector is legitimate. They have a consignment, and your creditor that you owe money to gives them permission to collect on the debt, and they come in and they say, well, we're gonna. Okay, so now you're talking to them. Now let's say it's a little bit before 108 days before they charge it off, whatever the case may be, and they try to get this thing resolved. If you owed them, if let's say you owed them $1,000 from maybe a $5,000 debt, and you fell on hardship, and let's say it's almost 180 days coming. Might be 170 days or 160 days, something like that, and they're coming after you. No, you have to do is negotiate. All things is negotiable in this type of space. $1,000. If you can scrape together 200, they'll take it. So I got $200. They don't take it, continue fighting. Wait them out. But don't admit to the debt. Because if you admit to that debt, if you admit to the debt, you know what I'm saying? Well, the debt clock is still there, so you're not going to restart the debt clock. You're not, the statutory limitation is not up. But because I was thinking about the debt clock. You got to excuse me. I had a lot of stuff in my head, but no. What will happen is that if they refuse to take the $200, just wait it out. Let them charge it off. But 9 times out of 10, they pretty much is trying to get this thing extinguished. And if they agree, you listen to me clear. I want to be clear about this. If that debt collector agrees to that $200, you have them to send it in writing on their letterhead, saying that they will that the debt is paid in full in accordance to satisfaction, no recourse. Paid in full. Let me throw you an alley-oop. If you owe the debt, and the debt collector if they had put it on your consumer report, right? You call up that debt collector and you tell them that you're going to pay them this amount, and they agree to it. Remember, in writing with their letterhead, stating that we agree that this is paid in full, and it will be upon paid removal of the consumer's credit report, paid in full with no recourse. This is how you do it. This is how you do it. You do not send them any money until you get it in writing. No money order, no check, none of that. And let me say one more thing to you people that's desperate. So many people operate in being desperate of trying to get it done. Let me say this. Do not give them your bank account information ever. Never give them your banking information. I don't care who they are. If you're not going to give me your banking information, you don't give them your banking information. And you don't know me. You don't know me, and you don't know them. So I hope we're clear on that, and I hope that makes sense to you. But anyway, but that's how we get them to back off. I want to say something real quick before I end this segment. I know it's stressful. I know you're tired of them calling your house, calling your cell phone, maybe calling your house phone, calling your job, maybe calling, sending your letters. I know you're tired of it. This might be your first time dealing with this mess. And you're scared. You got fear. You know what I'm saying? But one thing you must keep in mind is that debt collectors, debt junk buyers, have no rights under the Fair Credit Reporting Act, Fair Debt Collection Practices Act, TILA, the Federal Code of Regulations, the Uniform Commercial Code. It doesn't make a difference. They don't have no rights under any of them laws. Don't nothing protect them. Nothing. Only what you do give them rights. Your actions can give them rights. For example, you're not showing up to court. They got a right to come after you. You're not answering their letters. They got a right to come after you. See, you just gave them rights. Should never get to court. Don't give them no rights. The rights they get is because you give them to them. You don't answer their letters. Now they just did an administrative process on you. Now you got a summons in the mail. The sheriff is coming and putting the summons in your hand, telling you got to come to court. Now you're going to go to court. Now what you going to do? I want to do a segment on court. Because those of you that has court cases, you need to know this information. I really want to talk. I'm going to talk a little bit more about that. I don't really talk too much about it because my thing is it should never get to court. But I'm going to go into what happens when it does get to court. Because believe me, when I tell you, I had to deal with that mess with a client. I had a client that that let it get to court. The summons came and they had to go to court. They called me up on the day they had court. And I told them what to do. And they won the case. But we'll get into that. We will definitely get into that because, I had like two cases. One of them lost and one of them won. I'm telling you. Let me tell you something. When you win or when you lose, it's on you. Let me show my camera straight. Oh my gosh. I don't want to be crooked. But I'm sorry. I'm sorry to laugh because it's very funny. Because it's true. This is true. Court cases, when you go to court, right? Whether you win or you lose, it's all on you. How you make the presentment is all on you. Because number one, the judge want to work in your favor. You know what I'm saying? Because you're the defendant. The plaintiff have to prove their case. And they can't. The judge don't have, listen, those attorneys don't have first-hand knowledge on anything that's going on. So it's on you as the defendant on what you say that's going to give them whether the judge going, whether you going to win or lose, because they can't prove anything. So, but my first client won her case. She won her case. My second client, man, he was dumbfounded. He didn't want to listen. If he would have just came to my house and sat with me for 15 to 20 minutes, I would have went over the whole entire thing with him, and he would have never lost. Period. And I dealt this mess. It's stressful. Oh God, it's stressful. But they want it to be stressful so you can lose. They want you to be stressful. All this stuff is a mind game. But you got to have the upper hand. And knowing your rights, puts you back in control. I am your host, Foresight. And this is Blind Intelligence. Leave me a comment and share this video. Oh, and stay encouraged.